With just 2 weeks to go before the trial, attorneys for James Crumbley make a major request. They say the Oxford school shooter's texts and journal should not be allowed as evidence for the jury. James Crumbley's defense attorney using a new tactic in hopes of keeping her client from avoiding the guilty verdict that landed on his wife, Jennifer.
A jury found her guilty of 4 counts of involuntary manslaughter, and she's awaiting her sentencing in the case on April 9th. James Crumbley's trial starts March 5th, and there are numerous motions attempting to prevent evidence from getting before the jury. Rod Maloney was in court for this morning's hearing. Rod, somehow the big news, though, happened outside the courtroom.
Well, and in fact, it just happened a few moments ago where Judge Cheryl Matthews went ahead and agreed to allow the defense to have what they call more preemptory challenges. That's when they go to seat jurors. If the defense doesn't like that particular juror's answer, they can keep them from being in the jury pool. That just came out. But then there's also this from last night, which you've already talked about, and that is to try and keep the journals and the texts out of the case. That's not heard today. There was another motion heard today. Let's find out about that. 47-year-old James Crumbley entered the courtroom accompanied by the usual high security. Unusual was the sight of his lawyer, Mario Lehman, placing headphones on him to better hear the proceedings. At issue, whether 3 students involved in the shooting could testify. Assistant Prosecutor Mark Feast telling Judge Cheryl Matthews he actually is only interested in the testimony of 2 former students to augment the silent security video of that shooting that the judge already allowed into evidence.
So these are the 2 individuals that have the best perspective, who are now above the age of 18, who can actually testify as to what they saw, what they felt, what they heard as the shooter emerged from the bathroom and opened fire.
Keast adding the other student is under 18 and now not needed considering the emotions involved. Yet it's exactly those raw feelings why the students should not testify, says Mario Lehman, James Crumbley's attorney.
The primary purpose of their testimony is to inflame the emotions of the jury. I mean, their testimony or whatever they can provide can also be provided in a video. The whole purpose of admitting the video and not having sound on the video was to lessen the prejudicial impact on the jury.
Judge Matthews didn't immediately rule on that question, but did allow the Oxford man, who previously owned the gun used in the shooting, to testify.
I was sort of racking my brain to see why he's relevant, but now I think he is.
Now, what the point there that the prosecution put in is that man knows about a gun lock that was sold with the gun when he sold it back to the Oxford gun store, the store that the Crumbleys went and bought that gun from. So she is going to allow that testimony, and we'll hear more about that in the days to come. Back to you.
Rod, is the defense still asking for a change of venue in this case?
Indeed they are. It's another one of the flurry of motions that they put out there, and in fact that's going to be a part of a hearing. All of the information, or most of the information that you heard talking about the texts and the journal and also the change of venue, is going to be taken up in a hearing next week right here at the courthouse.
And we'll be following it. Okay, Rod, we appreciate it. And as the trial for James Crumbley approaches, we're going to be streaming every minute of the proceedings live on Local 4+. We'll also have exclusive analysis and daily recaps of everything that happened. Again, the trial is set to get underway March 5th.